Mr. Follow-up. My lady, will your answer be different if you find instances where chiefs who are also judges meet political heads, candidates, and they start talking, yes, we are with you, we'll make sure you win, and so on and so forth. Appearing before that judge, with that sense of neutrality still be there. I mean, the cloak would have been taken off him for the comments, some of these comments. Meanwhile, the chief probably is just looking for development for his people, but his comments, may be taken as a very weighty matter, which would take him to the side of politics and remove the neutrality cover.
Thank you, Honorable Chair. I believe that as a judge and a chief, you ought to be measured in your commentary on politics, especially in support of one group or the other. So I believe that the judges are able or should be able to be measured in their language. Thank you very much, Chair.
It's now the turn of Honorable Haji Aladi Ayamba.
Thank you, Chairman. My sister Amaleboba, Lahotuma Mahumaya. Well done.
Thank you very much, Honorable Chair.
There is the issue of whether or not to cap the number of Supreme Court judges. Currently, according to information, we have 13. If 7 of you go in, and inshallah you will be 20. What is your suggestion about the numbers? Should we add up, just leave the law like that, continue to add up, or we should cap it?
Thank you, Honorable Chair. I believe in capping the number of Supreme Court judges, but I believe that we should not to do so until we resolve the issues that confront the Supreme Court, which require that numbers be increased. Because if we cap it and there's a justification for an increase, it would mean that we would subject our Constitution to constant amendments, and that will not be desirable. But if we are able to solve the problems at the Supreme Court, the backlogs, the various jurisdictions that it has, then we would have a fair idea of how many cases on a year-by-year basis would go to the Supreme Court, and then we can have enough reason or basis to cap the numbers. Thank you, Honorable Chair.
Chairman, my second question. My second question has to do with the establishment of regional tribunals, and that is Article 142. And when you look at it, the membership shall consist of the Chief Justice, 1 chairman, such members who may or may not be lawyers. Do you subscribe to having regional tribunals? And if the Chief Justice is supposed to be part of the panel there or the team there that is going to work, how do we get enough of such people at any given time so that the Chief Justice hasn't come, so we do not know what to do? Let us postpone the case, let us hold on, and maybe when she's ready or when he's ready, then the case will be heard, where our cases will be prolonged.
Thank you very much, Honorable Chair. I do not know the policy rationale for why the tribunals, the regional tribunals, were abolished, so to speak, or were subsumed into the regular court system. but it still remains part of our law. And the law says that it is the duty of the Chief Justice to establish regional tribunals, and the duty of Parliament to prescribe exactly what their jurisdiction should be in respect of state matters and public interest matters. And so, insofar as the regional tribunals still remain part of our laws, I do not have any aversion to regional tribunals. I would also like to say that the Chief Justice is a judge of every court in Ghana. The Chief Justice is the first judge of every court in Ghana, but she does not sit when it's empaneled, even though she can decide to sit. So ordinarily, a 3-member tribunal doing its work would not require the presence of the Chief Justice to sit. Thank you, Honorable Chair.
Thank you, Chairman. I'm most grateful. I wish you all the best.
Thank you very much.
Thank you. I'll give the floor to Honorable Bit Zidin Awantazuma.
Thank you very much, Honorable Chairman. Your Ladyship, congratulations for the nomination.
Thank you very much, Honorable Chair.
And we, the Upper Westerners, we are very proud of you.
Thank you.
I made this statement when His Lordship, Surbare, appeared before us. And I indicated that we are happy to have 2 Supreme Court judges coming from the Upper West region. You will be approved.
Inshallah.
And we are further proud of you because we have the first lady Chief Justice also coming from Upper West. We hope that in course of time, our colleagues in the other northern regions will also benefit from this exercise. Anyway, ordinarily, I should not be asking you any questions, but I'll just ask you one question. But even before the question, some small comment. You are a Christian, but it's surprising that your first name appears to be a Muslim name. I'm curious about that. I will not expect any response from you, but it is interesting that you are a Christian and yet you have a Muslim name. I believe that the second name is your husband's name. So it is all good. Mr. Chairman, you are not happy, eh? The way you are looking at me.
Yes, because you are to ask questions.
Yes. I'm coming.
You are not to run commentary. And you know you are violating the rules of the House.
So, sometimes.
So you don't expect me to be the rules.
Thank you very much, Mr. Chairman. The question is, the retiring age of public servants in this country is 60. Sometimes it is extended to 60, a maximum of 65, 61, 62, 63, but maximum of 65. But justices of the Supreme Court, they retire at 70. So it appears there is some discrimination because these categories of people are all serving the Republic. Your Ladyship, in your view, is there justification for the difference? Other public servants retire at maximum, judges retire at 70. Is there any justification for this difference? Thank you.
Thank you, Honorable Chair. The justification that I see is that in the administration of justice, we need qualified, experienced jurists to be able to adjudicate matters that will stand the test of time and to be able to also guide relatively younger judges on how to proceed. So we need experienced jurists in the Supreme Court because that is our final appellate court. It is also our constitutional court, and it has various other jurisdictions. So I believe that the age is important because of the experience and qualifications that the jurists would have gathered over the years. Thank you very much, Honorable Chair.
Mr. Chairman, that will be all for now. Thank you. And I wish you very well.
Thank you very much, Honorable Bid. Yes, Patrick Yauboma.
Thank you, Chairman, and congratulations, my lady. Thank you. My lady, I've gone to your CV, and I've realized that you've chaired quite a number of committees aimed at reforming the judiciary, or the judicial service. Committee to investigate allegations of procurement of fraudulent divorce certificates and other court documents, 2023. Committee for setting up attestation units in other regions and for digitalization of the said units, 2023. Committee for implementation of recommendations made by the committee to investigate allegations of procurement of fraudulent divorce certificates and other documents, 2024 to date, and a host of other committees. From you, the process has gone on with regards to some of these committees that you've chaired, and remedies they seek to achieve, advancing our judicial process and also promoting the integrity of the courts. Thank you.
Thank you very much, Honorable Chair. In respect of the procurement of fraudulent documents and the attestation, two are linked. So it is the aim of the judicial service to ensure that people do not procure fraudulent divorce certificates and documents and parade them as coming from within the judicial service. So what has happened so far is that we intend to start a process. We are just at the implementation stage. We intend to start a process of ensuring that divorce certificates have special features, and that special seals are given to judges, and also electronic signatures are used for these documents. We also intend to ensure that each certificate would have a barcode so that if you have a smartphone, you can scan the code, and that will tell you whether or not the certificate is coming from within the judicial service. Now, with the attestation unit, we are yet to start work on the attestation unit. And the intention is to digitalize the attestation units. Attestations are done through a system electronically so that we take out the manual attestations which can be forged by people outside of service. But if we have all of them passing through the system, then it's easy to track and ensure that we don't have forged documents out there. But with the attestation unit, what has started happening is that if you take a document to the attestation unit for attestation, your ID card would be taken and a photocopy would be made of it. Now, and documented, if it is realized that the document is a forged document, you will be reported to the police and you will be arrested. So that is how we have started working in respect of these committees. Thank you very much, Honorable Chair.
Chair, and a follow-up, and are you receiving the needed funding to ensure the actualization of this project, and from where?
We have not yet requested for the funding. For now, the attestation unit is using the resources it has at its disposal to ensure that this is done. But we will get to that stage where all of the various departments involved will come together, the budgets will be drawn, and then the necessary things will be done. Thank you very much.
Chairman, I'll go to my second question. My lady, after this question, I'll let you advise those of us around the table. We politicians, those of us here, we tend to play politics with a lot of things. When it comes to the appointment of judges, independent constitutional officers, we talk a lot. You read our Hansard, the debate, so partisan in nature. In 2022, you got the opportunity to be nominated to sit on the Court of Appeal. Some justices sat at the High Court, straight to Supreme Court. Some 1 year at the Court of Appeal, straight to Supreme Court. Some became Chief Justices and what have you. I believe when you go to the Court of Appeal, you met some senior members too there, and by God's grace, you've gotten the opportunity to be nominated. What would be your advice to those of us around the table that nominations are not political, but based on certain steps or considerations? And that's one of the reasons why you are before us. So what do you have to say to some of these things? You see you politicians.
Honorable Chair, I would pray to let the cup of advising the politicians pass from me. But what I would say is that, indeed, I met some judges at the Court of Appeal, and I have a lot of respect for my esteemed colleagues on the Court of Appeal bench. Nominating a judge for the position of the Supreme Court is the prerogative of the President. And the President has done so. And I believe that I'm qualified. I have spent 15.5 years in private practice. I've spent 11 years on the bench. I'm 26 years at the bar. In accordance with the constitutional requirements, I'm capable, I'm competent, and able to discharge the duties of a Supreme Court judge. Thank you, Honorable Chair.
Thank you very much, my lady. And I know you distinguish yourself and put to rest some of the debates some of our colleagues wage. My lady, can we look at the rules of fair trial, I think Article 19. It deals with a lot of issues when it comes to fair trial and what an accused person ought to be, the opportunities that accused person ought to be given, what have you. And reading that in conjunction with I think Section 96.7 of Act 30 on bail. Sometimes bail conditions are a bit too onerous that a layperson can easily say that this will amount to being denying the person bail or it amounting to punishing the accused person. It's a discretion given the judge, given the circumstances or the facts before the judge. how would you explain some of these factors to the list public as to what goes into the grant or some of the bail conditions that you give to accused persons, in order not for the public to think the accused person is being punished or being denied bail? Because I recall some comments by the late Justice Badigbe that some of the conditions may amount to punishing the accused person. I want to hear your thoughts on the rules of fair trial and bail conditions, which some of us deem too onerous in our opinions. Thank you.
Thank you very much, Honorable Chair. Well, the position of the law is that all offenses now are bailable. And if an accused person is granted bail conditions, which he or she deems are onerous, you have the liberty to apply for a variation of your bail conditions. And if you find a stumbling block in that court, you can appeal against those conditions. Because the aim of the conditions is not to punish the person, but to ensure that you will make yourself available for trial. And that at the end of the day, if you should abscond, the sureties who have signed your bond would be able to meet whatever conditions are required of them. And so it is not supposed to be a punishment. So if you are unable to secure bail or the conditions are onerous, you either apply for a variation or you appeal so that the appellate court can take another look at it. Thank you very much, Honorable Chair.
Thank you, my lady. It will surprise you that you appear before a judge and the mood of the judge will be that, oh, yes, I've refused your application, you can go up. Straight away. And without considering the merits of the application, say, okay, I've read and I'm refusing, you can go up. And you can easily tell from the court that the person wasn't minded to even listen to you or take into account the conditions that the judge was setting. And it becomes problematic because I was in court one day, the accused person had served his term, it was left with only 3 months, and the lawyer was making an application for for a variation of a certain order that the judge had made. He said, oh, no, I'm refusing it. You can go on appeal. The person was 3 months, and it was within the judge's remit to consider the application before her. And it became some banter between the lawyer and the judge in open court. And those are some of the things that I believe that when you go for training, you can look into some of this. The temperament at the bench sometimes makes lawyers exchange, for want of a better word. Thank you very much, my lady.
Thank you very much, Honorable Chair. I believe that the JTI would take that into consideration and ensure that the appropriate training is done. Thank you.
My lady, on that note, I wish you the very best, and God bless you.
Thank you very much.